Mr. Souza.
Sir, the amendments in this bill relate to different stages of the criminal justice process, from investigations to pre-trial disclosure, as well as post-trial procedure. In terms of investigations, Clause 3 of the bill allows officers of prescribed law enforcement agencies to investigate offences relating to video interviews. This is good, as it streamlines the process by allowing the agency which is most familiar with the circumstance to investigate the offence, thereby smoothing the process. In order to fulfill such duties, is it envisioned that the skill sets and expertise will be slightly different from what the officers from the prescribed law enforcement agencies are already using? If so, what training or arrangements will be provided to ensure that the officers will be able to develop the necessary expertise, tap into the requisite resources to investigate each case? Still staying on this issue, why does the new Section 40B remove the need for an officer to be of an equivalent rank to that of an inspector of the police without seemingly replacing it with an equivalent safeguard? Allow me, sir, at this stage to declare my interest as a lawyer in private practice who sometimes acts as defense counsel. Moving on to amendments relating to the pre-trial and trial stages, Clause 9 provides for the non-disclosure of sensitive information and a process for it, that is, seeking a balance between the accused's rights and interests with that of others. For instance, while sensitive information may prejudice public safety, safety of any particular person, or future investigations, the prosecution may still need to disclose it if it is required by law, and if it undermines the prosecution's case or strengthens the defence's case according to the new Section 425B sub 3. Additionally, by the words, I quote, if the defence is aggrieved by the removal or redaction, unquote, in the new Section 425B, it seems as though the court's determination on the matter can be easily sought by the defence. Is this the case? While not allowing the defence to be present as the court views the document makes sense in order for this non-disclosure to be effective, would this be an exception to Rule 30 of the Legal Professional Conduct Rules 2015, under which legal practitioners are ethically bound not to initiate communication with the court unless he or she has given each legal practitioner acting for another party to the proceedings an opportunity to be present or to reply? That's my question to the SMS. Further, how does the process take into account the general understanding that the defence would be best placed to know whether something would strengthen its own case? Another question. These concerns must be weighed against the importance of protecting sensitive information. A correct balance must be struck. The provision could protect public safety, public security or propriety, public order, national interest, national security, safety of individuals, ongoing and further investigations, and interests of justice in criminal investigation or proceedings. Even as the accused must be able to present the best case, such important concerns cannot be compromised if there is no need to, especially if it does not weaken the prosecution's case or strengthen the defence's case. However, when there is a need to disclose such information, even though it is sensitive information, what will be done to safeguard the sensitive information from being abused? Similarly, how can we be sure that information is indeed disclosed even where it is valuable or relevant and necessary to the defence's case? Post-trial, certain timings for both the application for leave of review application as well as the hearing of a review application can be abridged through clauses 7 and 8, as these two powers would be able to shorten the time from those prescribed in the criminal procedure rules, potentially prejudicing the relevant parties. Would the SMS please explain the rationale behind these amendments? The fourth area of substantive amendments that I want to speak about in this very short speech is that of reformative training. The reformative training regime is an important feature of our criminal justice system through both rehabilitation and deterrence. Clause 6 removes the ability of courts to backdate reformative training. While this removes the period that the accused was remanded for pre-sentencing, this amendment furthers the aim and purpose of reformative training. As the Singapore High Court, in the case of Nur Azila binti Ithnin against public prosecutor, opined, backdating reformative training will shorten the period of training and could undermine or hinder the effectiveness of such a program. As such, this amendment will promote the effectiveness of the reformative training program. Following the Criminal Justice Reform Bill of 2018, which allowed for a more calibrated rehabilitation program through changes to the duration of the reformative training regime, this amendment will further enhance the effectiveness of reformative training and is a welcomed development, a welcomed amendment. Nevertheless, what will be done to ensure that the duration of remand will be reduced or minimized? Additionally, since corrective training also contains rehabilitation as part of its focus, did the Ministry consider introducing a similar change to disallow backdating for corrective training? And if so, why was it not extended to corrective training? Sir, in conclusion, all stages of the criminal justice process are important. The Criminal Procedure Code is integral to our criminal justice system. In order to achieve justice in our criminal justice system, the process must be robust, yet flexible, balanced, and fair. It has to take into account both the interests of not just the accused, not just the victim, but also that of the broader society. Hence, I support this bill.